Good evening, everyone. So, our last tutorial is on the topic the relationship between the WTO agreements and multilateral environmental agreements and other treaties. So, it's very important because of so many reasons. So, anyone would like to highlight any of the reasons that actually come to your mind very quickly? Why we should think about the relationship between yes.
WTO agreements again don't explicitly cover anything environmental related, so they should be read in conjunction with MES for a better sort of environmental application of trade law.
Okay, there should be coherence.
Yes, if any multilateral environment agreements lead to spilling over consequences in trade relations, then
Yes.
WTO, so basically it's very harmony wala India, and also because they will have spillover effect. So any WTO effect will have effect on obligations of nations under this MES.
Okay, so basically these spillovers are of such a nature that there will be continuous interaction between the WTO agreement and again MES with respect to environmental matters that are having some trade impacts, right? Anything else? So the first point that you need to note is that WTO agreement is actually a formal treaty that we all know. It was concluded in the manner that is actually required for conclusion of a treaty in international law. So we are considering WTO agreement as an international agreement. And again, if you look at WTO, the World Trade Organization, it's actually fulfilling all the requirements of an international organization. Okay, so the place of the World Trade Organization is very well identified in public international law. So it's within the boundaries of public international law. Therefore, it's very important that we note that WTO agreement could not be read in clinical isolation from public international law. So all the principles or maybe all important aspects that we consider in connection with the interpretation of an international treaty that are applicable to the WTO agreement as well. So this was basically noted by the appellate body in US gasoline case. It was the first appellate body report of the World Trade Organization in 1996. And the implication is that as this is the case, the interpretations that should be in tune with Article 26 of the Vienna Convention on Law of Treaties, 1969. And what exactly is the spirit of Article 26 of the Vienna Convention on Law of Treaties? At the first place, every treaty in force is binding upon the parties to it. That's a fundamental principle. And again, must be performed by them in good faith. Okay, so parties, they are obliged to follow their obligations within the treaties that they have signed, and again the obligations must be performed in good faith. So what exactly is the relationship between WTO agreement and multilateral environmental agreements? So as we are discussing about multilateral environmental agreements, of course we can say that environmental issues are not generally affecting one particular state or the other. It can have transnational effects or cross-boundary effects. So whenever we try to provide a solution for multilateral problems, okay, it should be through multilateral treaties. Multilateralism should be the solution over and above unilateralism. And again, this particular idea that you could actually see as part of Agenda 21 of the Rio Declaration also. Okay, how important multilateralism for the purpose of resolving environmental issues over and above unilateralism. So if we follow unilateralism, then what would have been the problems? There can be excessive protectionism, or there can be some other dangers that some states might be interested in giving extra importance to their national preferences over and above the general interest that are being shared by different nations. So multilateralism is the solution. So therefore, in the context of environment, we are having multilateral environmental treaties that is also very much needed. So whenever we look at the relationship between WTO agreement and multilateral environmental agreements, there are two important aspects making these two agreements related. Okay. At the first place, both the WTO agreement as well as multilateral environmental agreements, they provide for detailed rights and obligations of the parties. If you look at the WTO agreement, that is actually listing the rights and obligations of the parties. And again, there can be different sets of rights and obligations under multilateral environmental treaties or agreements. And again, both the systems, they provide for different dispute settlement mechanism. The dispute settlement mechanism under WTO agreement, that is one. And again, the dispute settlement mechanism that we are finding under multilateral environmental agreements, that can be different. And again, there can be various options for the parties to settle the disputes under multilateral environmental agreements. And again, because of these relationships or relating aspects, what are the problems that we generally see? So can you imagine any of the problems because of these different sets of rights and obligations and the opportunity or availability of different dispute settlement mechanisms?
One country is involved in dispute in both of these cases, adjudication bodies, and they get some obligations being told to them as part of the adjudication process that interferes with the obligations on the other side. So, for instance, WTO panel says that you should not give subsidies for your domestic products, but at the same time, your MEA says that you should support the industry for sustainable things. And how does one support? They subsidize. So, if such a matter arises, then that is the kind of conflict that may happen.
Okay. Any other observation? Okay, we can probably classify the potential conflicts into different categories. Okay, the conflicts between two states that are members of WTO as well as members of multilateral environmental agreements. Okay, and again, conflicts between WTO member state and again, a state which is not party to a multilateral environmental agreement. Okay. So if both the states are parties to multilateral environmental agreements, it's quite possible that there can be resolutions within the limits of the multilateral environmental agreements. That is one way of approaching it. And again, if you look at the parties, one party is a WTO member and the other one is not a party to multilateral environmental agreement, then definitely it cannot be resolved under the dispute settlement mechanism of multilateral environmental agreement. But considering the fact that both are WTO member states, there can be a resolution of the dispute under the WTO dispute settlement system. Okay, then conflicts between rights and obligations contained in two different treaties that apply between the same states. So that is one of the categories. And two institutions or two adjudicating bodies claim to have exclusive or permissive jurisdiction to address the factual or legal aspects of a matter having trade and environmental dimensions. Okay, so we know that the WTO dispute settlement system actually features the jurisdiction of WTO dispute settlement body over and above matters that are having connection with trade aspects. Okay, so irrespective of the fact that it's something that is actually related with environment, you can probably think of an environment trade interface and the relationship of trade with environment that can actually bring that particular claim within the framework of WTO dispute settlement. Okay, then there can be these arguments. Okay, as it is a matter concerning trade, WTO has exclusive jurisdiction. And then probably depending on the nature of the multilateral environmental agreement and who are the parties, there can be this particular argument also. As this is a matter concerning trade and environment and within the framework of so-and-so multilateral environment agreement, so this particular MEA should have exclusive jurisdiction with respect to the dispute arising from such a situation. Okay. And it would be interesting to know some of the main trade measures within multilateral environmental agreements. They can take the form of trade bans, export-import licenses, notification requirements, packaging or labeling requirements. These are some examples for your understanding. And again, we can see some of the multilateral environmental agreements with trade measures. If you look at the total number of multilateral environmental agreements, can you make any guess how many multilateral environmental agreements are there? Any guess? Maybe 200. Okay. And out of these 200 MEAs, we can actually find trade provisions in around 20 of them. These are some examples where we can actually find a trade measure as part of the multilateral environment agreement. Convention on the International Trade in Endangered Species of Wild Fauna and Flora, Montreal Protocol on Substances that Deplete the Ozone Layer, Rotterdam Convention on the Prior Informed Consent Procedure for certain hazardous chemicals and pesticides in international trade, and Basel Convention on the Control of Transboundary Movements of Hazardous Waste and their disposal. You can probably check for other MEAs also that are having certain trade measures, but these are very relevant from the point of view of certain overlaps and interfaces that these agreements are having with the WTO agreement. So how do we actually look at or examine the relationship between the WTO agreement and various multilateral environmental agreements? So the very important approach is that of giving importance to substantive as well as procedural aspects of the relationship. And you might be thinking why the procedural as well as substantive matters are important here. So I have given certain reasons why we should look at substantive as well as procedural aspects whenever we examine the relationship between the WTO agreement as well as the various multilateral environmental agreements. The first point is that of jurisdiction. What exactly is the jurisdiction of the WTO dispute settlement panels? Definitely, we know that they have jurisdiction with respect to all WTO related matters. We can probably make a reference to Article 23 of the Dispute Settlement Understanding. If there is a matter that is actually having a trade connotation, then that could be brought within the purview of WTO dispute settlement mechanism. And as a multilateral dispute settlement mechanism, the WTO dispute settlement panels could actually assume exclusive jurisdiction over that particular matter also. And what is the applicable law? Definitely, no doubt, it is the WTO law. Of course, we know that whenever there is a determination as to the law applicable for a matter before the WTO adjudicating body, the question before the panel is that of whether the measure in question has actually violated the WTO law. Okay, so we can say the applicable law is that of the WTO law. And again, if we look at the interpretation of WTO provisions, we know that it's always favored or recognized that avoiding conflicts with other international obligations of WTO members is of utmost significance. Okay, so therefore we can say that as we are going for such an interpretation, making coherence between different agreements, there is less chances of conflict. But at the same time, there can be irreconcilable conflicts. And what are irreconcilable conflicts? And what would be the impact of irreconcilable conflicts? Suppose the provision or maybe the law applicable or that has to be considered by the WTO panel for the purpose of interpreting the WTO provisions that has certain interface with other treaties or agreements, and the WTO panel has to examine an international law provision for the purpose of giving importance to the WTO provision. You are basically checking whether there is a coherence or not. If there is an interpretation possible giving coherence, then you will follow that. What if there is no interpretation possible giving a coherence between these two provisions? Okay, so if a coherence is not possible, okay, then we can say that this is a case of irreconcilable conflict between the WTO agreement and again the principles of international law under other agreements.
Even
Yes.
if there is no coherence, both of them can just decide that this is going beyond my jurisdiction and I will only decide on where my agreements are on the dispute. So even if this dispute has multiple perspectives to take on, once WTO decides or understands that its obligations are, not in coherence with the other one, it can
Yes.
just say that I will only decide based on these agreements that are under in my annexure, and whatever your obligations are that are not in coherence to me will be decided by them, and they could be two different obligations.
Of course, probably the same obligation can be explained in different manners. Say, for example, the most favored nation treatment. So, under the WTO law, it's very much clear that whatever treatment that you are extending to a particular product, like product coming from one particular country, that should be extended to a like product coming from another country. Okay, so irrespective of whether that particular country is a member state or not for that particular matter. But whenever the same provision comes within the ambit of a multilateral environmental agreement, you can see that benefits are given only for members who are actually attached with that specific MEA. Okay, so a non-party may not be, or a third state may not be getting the benefit of most favored nation under that particular MEA. So there can be different conflicts, but I just thought of picking up the easier example so that everyone could understand what can be the nature of different conflicts or what can be an irreconcilable conflict. Okay, or maybe with respect to the imposition of quantitative restrictions. You can give certain guidelines. Of course, we know what are the requirements under, or maybe no quantitative restrictions, only tarification. That is basically the rule under WTO. But you can probably find this is possibly one of the trade measures under MES, some quantitative restrictions. So there can be conflicts, okay, within the WTO law in comparison with the MES. So WTO adjudicating bodies are prohibited through the dispute settlement mechanism and while making recommendations to DSB from adding to or diminishing the rights and obligations of WTO. Okay, so the question is that to what extent WTO panels could actually examine the public international law obligations or give effect to international law obligations while addressing an issue that is within the jurisdiction of WTO panel. Okay, and if the nature of the international law issue is such that it may result in adding or diminishing the rights and obligations of WTO, WTO is not expected to do that. Okay, So we cannot say that WTO is exclusively the forum for WTO dispute settlements or maybe for disputes that are having certain trade aspects. Whether the dispute resolution of that particular trade aspect is having certain connections with principles in international law and the reference to those principles, what is actually the impact of it, whether it is resulting in adding or diminishing the rights and obligations of WTO. Okay, so if the answer is yes, whether there is adding or diminishing the rights and obligations of WTO by giving importance or while you are interpreting a particular aspects in reference to international law, then WTO is not basically the forum. So there can be a conflict from the point of view of Article 23. And again, the significance that we are giving from the point of view of interpretation, because WTO law is within the framework of international law. So we should apply the principles of international law that are relevant in the context of other treaties or agreements. And again, it would be very interesting to see the definition of a conflict. If there is a conflict, then only there is a problem. Right? If there are no conflicts, we should not worry about the dispute settlement. It can be either under the WTO framework or under the framework of multilateral environmental agreements. So it's quite possible to have a narrow definition as well as a wider definition. So both are actually tested. And if you look at the narrow definition, what exactly is the nature of narrow definition? For a conflict to exist, three conditions must be satisfied. And what are these three conditions? At the first place, two states must be bound by two different treaties. And secondly, the treaties must cover the same substantive subject matter. And thirdly, the provisions must conflict, imposing mutually exclusive obligations. So if these three conditions are met, we can say that there is a conflict and that particular definition is considered as a narrow definition, because we will see what exactly is the nature of the wider definition in some point of time. And again, this was applied in the context of the Guatemala cement case. Of course, you know that there are specific provisions with respect to the dispute settlement relating to anti-dumping, as well as the general provisions of dispute settlement DSU, as well as special rules governing dispute settlement under the anti-dumping agreement. So both are basically within the WTO framework. And in this particular case, the appellate body observed that a special or additional provision should only be found to prevail over a provision of the DSU in a situation where adherence to one provision will lead to a violation of the other provision, that is in the case of a conflict between them. Okay, so if you go by the narrow definition, it's clear that if he adhere to one provision, that will actually result in the violation of other provision. That is basically the context of a conflict within the narrow definition of conflict. And let's see what is the wider definition. The wider definition is actually given by Laurent Bartels, and according to him, a treaty which defeated the object and purpose of the earlier treaty should be seen as conflicting with the earlier treaty. So it's basically based on the object and purpose of the subsequent treaty. Whether the subsequent treaty is actually violating or in conflict with the object and purpose of the earlier treaty. So if that is the test, definitely he argues that it can be supported by Article 41 of the Vienna Convention on Law of Treaties. And what is Article 41? Of course, we know that Article 41 prohibits parties to a multilateral treaty from concluding any treaty interstate that is incompatible with the effective execution of the object and purpose of the main treaty as a whole. So you cannot even think of entering into a treaty which is actually violating the object and purpose of the main treaty. That is Article 41. And again, this particular definition, wider definition, is supported by Article 18 of PCLT also. Of course, Article 18 obliges a state that has signed but not ratified a treaty to refrain from acts which would defeat the object and purpose of a treaty. So, irrespective of the fact that you have not ratified the treaty, okay, you are still bound to ensure the object and purpose of the treaty for which you have put your signature. You have not ratified it, that is not an excuse. So basically the test is that of whether the treaty actually violates the object and purpose of a treaty that you have already agreed upon. Okay? If yes, then there is a conflict. That is the wider definition. And again, we could see the application of this wider definition in the WTO context in the EC Banana 3 case. Okay, the appellate body report again you could refer to. So, one particular act permitted under one agreement that is actually prohibited under the other agreement. Okay, so we could actually refer to such examples to show that there are basically options that are tried out in the context of WTO itself for the definition of a wider conflict, with respect to multilateral treaties. And again, what are the rules of international law on conflict? Definitely, the basic principle of interpretation is Article 31 VCLT. Okay? And Article 31 VCLT, that is actually saying that the ordinary meaning of the terms of treaty in the light of object and purpose of the treaty should be taken into account. Okay, ordinary meaning in the background of the object and purpose of the treaty. And again, secondly, you can also look into the context of the treaty. And finally, some actions of the parties following the conclusion of the treaty that also could be considered together with the context of the treaty. Okay, so that is Article 31 of PCLT. And again, there are two important principles. One is lex posterior derogate priori. That means the law which is later in effect, that will actually precede the earlier law. Okay, so we know that definitely you are concluding this particular treaty later in time. That means the object and intentions of the parties are such that you want to give importance to the provisions of the later treaty over and above what you have already agreed at an earlier point of time with respect to an earlier treaty. Okay, and this is basically justified, or you can probably make a reference to Articles 33, 34 and 59 of VCLT. And second principle is that of lex specialis derogate generalis. Simply, the special law will prevail over the general law. So you cannot find a specific provision under the Vienna Conventional Law of Treaties dealing with this particular principle. But this particular principle was applied by the International Court of Justice in multiple cases. So some of the examples are given here. One is Mavro Matis, Palestine Concession, PCIJ, then Kosovo Factory and Rights of Passage case, and many other cases. I just thought of giving you some classic examples so that you can understand that even though there are no specific principle under the Vienna Conventional Law of Treaties with respect to the predominance of special rule over the general rule, this is actually very well applied by the courts and tribunals in various cases. And even we can take our reference to the cases by International Court of Justice. And again, with respect to the conflict between provisions or maybe the potential conflict that we could imagine from the context of the WTO agreement and multilateral environmental agreements, the classic example is that of the Chile swordfish case. So how many of you are aware about this particular case, the Chile swordfish case? Okay, so you cannot probably find this particular case as part of the records because this was basically taken back from the panel constitution because there was an agreement between the parties with respect to their dispute that they were actually making and again pleading before different tribunals. So if you look at the facts, we can see, of course, we know that swordfish migrate through the waters of Pacific Ocean, and while they are doing their journeys, they cross the jurisdictional boundaries. And there were this particular issue going on between the European communities and again Chile for a period of 10 years. And, that actually resulted in this particular case that is actually being filed by the European communities before the WTO and again Chile before the International Tribunal for the Law of the Seas. Okay, so the WTO complaint was filed in April 2000 and the ITLO's complaint was actually filed in December 2000. And what were the proceedings at the WTO? So, in April 2000, the European communities requested consultations with Chile regarding the prohibition on unloading of swordfish in Chilean ports established on the basis of Chilean fishery law. Okay. So, the law enacted by Chile actually prohibited the transit of the swordfish through Chilean ports that basically affected the interest of the European community. So definitely what was the argument of the European community? So they argued that its fishing vessels operating in the Southeast Pacific were not allowed under the Chilean legislation to unload swordfish in Chilean ports. That is actually violating the WTO provisions, the GATT 1994 provisions, specifically Article 5 and Article 11. Article 5, your transit rights, and Article 11, of course, we are very well aware of Article 11. Okay. And again, in December 2000, the dispute settlement body established a panel so that there can be, certain consultations between both the parties and they can actually try. But in March 2001, the European communities and Chile, they agreed to suspend the process for the constitution of the panel. And again, this was reiterated in November 2003 because they reached an agreement. Okay. But there were proceedings before the International Tribunal on Law of the Sea, and that was actually started in December 2000. And that was again brought by Chile that we should not. And what were the requests of Chile? So Chile wanted the International Tribunal on Law of Seas to declare whether the European communities had fulfilled its obligations under UNCLOS Article 64. And what is Article 64 of UNCLOS? Calling for cooperation in ensuring conservation of highly migratory species. Then Articles 116 to 119 that are relating to conservation of the living resources of the high seas. Then Article 297 concerning dispute settlement and Article 300 calling for good faith and no abuse of right. These were the requests by Chile, before the International Tribunal on Law of the Sea. And again, if you look at the request by the European communities, we could see that the European communities requested the tribunal to declare whether Chile had violated Article 64, then 116 to 119 and 300 of UNCLOS. The same request that Chile had also made before the International Tribunal on Law of Sea. Then again, in addition to that, Article 87. So that is actually dealing with on freedom of the high seas, including freedom of fishing, subject to conservation obligations. And 89 also. 89 actually prohibits any state from subjecting any part of the high seas to its sovereignty. Okay. So in one particular forum, the WTO Dispute Settlement Forum, so there were discussions about one measure imposed by the Chilean government by passing a Chilean legislation prohibiting the swordfish unloading within the Chilean ports. Okay, that was argued as violation of Article 5 and 11. And what could be the outcome of it? You could imagine how the WTO would be deciding the violation of Article 5 and Article 11. Of course, we know that the applicable law is that of the WTO law, and we will follow the interpretations that are there for the interpretation of HET. By virtue of that, we will apply the mandatory principles of Vienna Convention on Law of the Sea. Definitely that will result in certain findings, okay, that can result in a decision that, okay, there was violation of Article 5 and 11 or there is no violation of Article 5 and 11. One hand. And if you look at the proceedings before International Tribunal on Law of Sea, it was not in any way connected with the arguments that are actually raised by the European communities before WTO, but that are actually concerning the provisions under the United Nations Convention on Law of the Seas. Okay, and different provisions were actually invoked before the different forums. Okay, so we can say that these are parallel proceedings, and the outcome of these two parallel proceedings could be different. Okay, so if you allow these cases to continue, we will ultimately reach a particular situation where one forum would be saying, okay, this is the outcome, and there can be an opposite decision by another forum with respect to the same factual matrix. Okay, so this would not be really good for our own expectation about certainty, and again different outcomes for same facts, same parties, and again same issues, that would not be helping us to solve the issue efficiently. Okay, so if there are problems that are having overlapping effects between the WTO agreement and multilateral environmental agreements, we should think of bringing a coherence between these potential difficulties or conflicts. Otherwise, there can be different decisions, and the different decisions, the outcome would be different, and that will definitely affect the general interest. Okay, therefore, what would be the way outs for us to actually bring coherence whenever there is a conflict between the WTO agreement as well as multilateral environmental agreements? Okay, so probably we could look at some of the initiatives that are taken by the Committee on Trade and Environment. Okay, and you could also see that there were so many discussions as part of various ministerial declarations. And again, the importance of looking at how different nation states are actually taking care of these issues within their national laws. And we can probably grab certain guidelines from the good practices within the national laws, because we know that for international law, the sources are under Article 38 of ICJ, and general principles of law recognized by civilized nations, that is one of the sources of international law. So definitely we could find solutions by looking at the good practices that are there under different national laws. And again, as different states are bound by their international obligations, so for the purpose of making these international obligations relevant in their national jurisdictions, they could think of following the international best practices so that we can probably look for some uniformity between national laws with respect to similar issues. Okay, so these type of initiatives, and again, apart from the ministerial declaration, of course, there are certain developments with respect to the relationship between TRIPS and the WTO agreement. And again, the significance of Convention on Biological Diversity and TRIPS agreement. TRIPS agreement is again another WTO agreement. Okay, so it is part of the WTO agreement, and all these aspects are very, very important. So all these overlapping effects, how exactly the various issues of environment is integrated within the WTO framework, and how these issues are actually interacting with other multilateral environmental agreements. So we need to have more international cooperation or international negotiations or consultations, keeping in mind multilateralism is the solution over and above unilateralism, and this can only give us better solutions. So if there is a dispute that is coming within the ambit of WTO law, let the WTO dispute settlement body find a solution provided both the parties are from the WTO member states, and there won't be any diminishing or adding effects with respect to the rights and obligations of the parties. Okay, but if both the states are MEA members or parties to a multilateral environmental agreement, it would be better, considering that that is a specific multilateral agreement dealing with these aspects, going for the resolutions under the dispute settlement mechanism of that particular agreement, and that is getting resolved. So we can generally say that the problem comes more often whenever the parties are actually not belonging to both the agreements. Okay, one is that both are WTO members but not the MEA member states. Then there will be more chances of having a problem. So the WTO dispute settlement system in that particular case should be sufficient enough to take care of that particular conflict, and at the same time they should ensure that it's not actually affecting the international obligations assumed by their member states with respect to their commitments under other treaties or multilateral environmental agreements. So we can actually do this because WTO agreement is at the end or ultimately an international treaty, and you can very well apply the principles of interpretation that we generally follow in the context of international law so that you can avoid conflicting interpretations. You can actually you can pick the interpretation that is actually providing for a coherence between the provisions under the WTO agreement and again the provisions under multilateral environmental agreements. And it would be interesting to see the end of this particular decision. So it was taken back, and so it was actually remained in the docket of the tribunal. So if this particular case could have been continued, then probably it would be a very difficult situation owing to the fact that we are actually having different conclusions with respect to the same facts, same parties, and same issues. Okay, so that's it. So if you have any observations or any comments, you are free to do that. Okay, thank you all for a patient hearing.